Thank you. Please be seated. Back to the Secretary Council's President. Mr. Sigg's President, Mr. Lord.
Your Honor, at this time, if Austin were to allocute, he would do that now, but I will inform the court that he is not going to. And that is undoubtedly in part due to his age, and that the court granted expanded media coverage in this matter over defense counsel's objection. So Austin will not allocute. He will not make a statement to the court.
Well, he has an absolute right to allocute, and an absolute right to have me here. With or without me here is an open courtroom. So is that his independent decision?
Yes, it is, Your Honor.
Do you want me to make any further findings? Do I need to make any further findings directly from Mr. Sigg as to that?
No, thank you.
You understand you have the right to say something if you want to, sir.
Yeah.
Thank you. Go ahead. Go ahead.
Your Honor, I'll address the legal argument of the sentence that we feel that is the only sentence that you may impose. And we submitted a memorandum of law to Your Honor, a memorandum of law in anticipation of sentencing, which is D67. It's presented as a memorandum, but at this point I orally incorporate that into my oral motion and objection to any sentence other than a sentence to life with the possibility of parole after 40 calendar years. Your Honor, the district attorney, Mr. Sargent's argument, Mr. Madoran's argument legally, much of that includes speculation and categorical language. The argument that's fine, Your Honor. You're my audience here. Thank you, Your Honor. Your Honor, the district attorney attempts to place adult logic and reason onto a child's decision. But, Your Honor, the Supreme Court's Eighth Amendment's jurisprudence regarding juvenile offenders has shifted significantly recently by recognizing that juveniles are psychologically and developmentally different than adults and therefore less deserving of the most severe punishments. Your Honor, in Graham versus Florida, the United States Supreme Court, they held that a juvenile lifetime without parole sentence for non-homicide offenses violates the Eighth Amendment's prohibition against cruel and unusual punishment. The court noted that a juvenile's diminished culpability required that sentences for non-homicide offenses must provide, quote, some meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. Later, the United States Supreme Court held in Miller versus Alabama, that case dealing with a homicide, the court held that for juvenile offenders convicted of a homicide, a mandatory, and I distinguish that, I recognize that, a mandatory juvenile lifetime without parole sentence is unconstitutional because a court would be unable to weigh pertinent evidence of the offender's youth in its sentencing decision. A juvenile's, and I quote, immaturity, impetuosity, and failure to appreciate risks and consequences are important factors in determining proportionality and diminished culpability. Your Honor, we get then into Colorado case law. And what we have to do is recognize...
Well, let me interrupt you just for a second. So then you're agreeing, as Mr. McGorn says, that for a homicide case, it is discretionary under the Supreme Court's opinion and not mandatory?
The United States Supreme Court does not explicitly state that the court can't impose a lifetime sentence. But what we get into is the state. The state of Colorado providing more strict or greater constitutional protections. And that is established, first of all, through the statutory language in 18.1.3.401, where, in this case, we're dealing with a Class 1 felony with a direct filing. The district court shall sentence the person, Austin, to a term of life imprisonment with the possibility of parole after serving a period of 40 calendar years. It's no guarantee to parole. When he hits after 40 calendar years, under the separation of powers, the parole board will make a determination when he's almost 60 years old whether or not he is appropriate. And the legislature gets into or creates this language because it does not impose upon you, Your Honor, as a trial court, the ability, or does not assume or speculate that you have the ability to look ahead to when Austin is almost 60 years old. You can't make a determination right now if he will be inappropriate for parole. The statute is clear that if he ever is able to parole, that he will then have lifetime parole. He is not just going to be released. He would be supervised by the parole board upon his release. Your Honor, we get into the Colorado case law. We first get into People versus Banks. There the court applied Miller versus Alabama, that standard, and held that the statutory mandate of lifetime without parole under which a juvenile defendant was sentenced was unconstitutional. So People versus Banks is establishing that a juvenile lifetime without parole for a homicide, applying Miller, was unconstitutional. They relied on Colorado's severability rules, and the court reduced the sentence to the longest sentence statutorily allowed in the remaining provisions, which was 40 years. We get into People versus Rainier, which I have attached to our memorandum of law. The court held there that a juvenile sentence of 112 years for a non-homicide was the functional equivalent of life without parole, and therefore was barred under Graham. The court found that such a sentence did not offer the meaningful opportunity for release that Graham requires, because Rainier would be eligible only after his natural life expectancy. So Rainier gets into the functional equivalent to a juvenile lifetime without parole, and finds that Rainier, dealing with a non-homicide case, was unconstitutional and consistent with Graham and Miller. Your Honor, if we marry these cases, if we marry them, Graham, Miller, Banks, and Rainier, Your Honor would conclude that there cannot be, even in a homicide case, which is the matter before you, even in a homicide case, there can be no virtual, there can be no functional, there can be no de facto lifetime sentence for Austin. Yes.
Assuming, and I understand your argument, assuming there are other charges in addition to the homicide, and And those other charges by statute or by case law are mandatorily concurrent, as has been presented and argued. Are you saying that I cannot impose I said concurrent.
You said concurrent, Your Honor.
Consecutive, I misspoke. If they're mandatorily consecutive, that means I cannot impose consecutive sentences?
Yes, Your Honor. The last page of my memorandum of law, I got into what I anticipated incorrectly that the prosecution would argue a people case close versus people, CLOSE, found at 48 Pacific 3rd, 528, Colorado Supreme Court from 2002. That case deals with if the court is able to look at a sentence in toto, a totality of a sentence, but close versus people was dealing with a proportionality review. And if Your Honor could look at it at not just the individual sentences of each convicted charge, but if you were able to look at them all together for purposes of proportionality. In that case, close, the court differentiates between a proportionality review and an Eighth Amendment cruel and unusual analysis. Your Honor must consider the Eighth Amendment cruel and unusual punishment in determining if a sentence combining every single sentence in each count would create a virtual or functional or de facto juvenile lifetime without parole sentence. The Colorado Court of Appeals specifically rejected the argument that close is binding in cases involved in juveniles and Eighth Amendment challenges to sentencing. In People v. Rainier, one of the cases I've mentioned to the court there states, and I quote, "We conclude that Graham effectively overruled close with respect to this particular class of defendants." The court may not impose a consecutive sentence because there's no way to do that with appropriately marrying Graham, Miller, Banks, and Rainier, because doing so would create a virtual, functional, or de facto juvenile lifetime without parole sentence, which, Your Honor, as applied, would be unconstitutional under the Eighth Amendment as cruel and unusual. Your Honor, for Austin, the language in Miller and Graham, Supreme Court, United States Supreme Court language, regarding the meaningful opportunity for release is important because it highlights the United States Supreme Court's understanding that juvenile offenders are different. Children are different than their adult counterparts and should be sentenced accordingly with that understanding. You know, I've provided to counsel and to you before the break statutory law, which I have filed it's under Title 13, and I may have given you my copy. You know, what it establishes, if I may, Your Honor, yes. Your Honor,
McGorn, did you rescind this?
Yes, sir.
Thank you. Please go ahead.
Your Honor, in Title 13, Statute 1325-102, it establishes a mortality table as evidence that is self-authenticating in modes of litigation in courts of justice, which we are dealing with here this morning. It states that for someone who is 18 years old, that they would live 59.6 years longer. Your Honor, imposing a lifetime sentence with the possibility of parole is nearly a de facto lifetime sentence. If you impose a consecutive sentence, you are getting into that dangerous area where marrying the United States Supreme Court cases and the Colorado Supreme Court cases would create a virtual lifetime sentence. Your Honor, I've provided to Your Honor filed as a submission of documentation in anticipation of sentencing, Department of Corrections treatment practices, which is D68. Your Honor, on page 4 of that document, we learn what is the Sex Offender Treatment and Monitoring Program of the Department of Corrections, their treatment policy. Their policy is that to the extent resources permit, offenders may be prioritized for treatment. A lifetime supervision sentence for offenders that are within 4 years of their parole eligibility date. What that establishes is that for someone who will have lifetime supervision, like Austin, he will not begin to receive therapy at the Department of Corrections until 4 years prior to his parole eligibility. He will be 54 years old when he will have his first opportunity for sex offender treatment and monitoring therapy. Your Honor, there is practically no parole board that will exist in the future that will send him out the front door, albeit heavily supervised through parole, after only 4 years of treatment. I say that because I don't want anyone, particularly you, Judge, to feel that a 40-year sentence will be in any way a free ride for Austin. Only after showing compliance, progression, and ultimately appropriateness for parole will the parole board allow him to parole. He will have to fully engage in the therapy. The nature of the parole board is one of self-accountability. There is a disinclination to release as they hold responsibility in part to their decisions and the subsequent actions of those people paroled. In People v. Rainier, the Rainier court, the Colorado court, recognized that 90% of those people eligible for parole upon their first opportunity for parole are denied. Your Honor, that is my argument, my legal argument, for why there should be no other sentence that you can impose other than a lifetime sentence with the opportunity for parole after 40 calendar years. Your Honor, I do have argument with regard to SVP finding that I'd like to do at this point, unless you have questions with regard to the legality of a sentence beyond the 40 calendar years.
You've answered my question, sir. Please, you want to go into your sexually violent predator findings? As I stated earlier, based on the offensive system evaluation that I received as part of the pre-sentence report, the adult sex offender pre-sentence report, their instrument said they had the findings that I should make. He is not a sexual offender.
Your Honor, I think you've made it clear that you are going to deviate from that finding, correct?
I find the finding has no foundation in fact. So, yes, I will.
Okay, so you will deviate, you anticipate finding that Austin Sigg is SVP. All right. Your Honor, then I do object to that in anticipation of that ruling. And Your Honor, you pointed out that the pre-sentence investigation report finds no SVP, no sexually violent predator designation appropriate for Austin Sigg. There is a reason you ordered the pre-sentence investigation. Of course, statutorily, you did that, but there is a reason for that. 18.3414.5 subsection 2 establishes this. Based on the results of the assessment, the scoring instrument that was attached to the PSI, the court shall make specific findings of fact and enter an order concerning whether the defendant is a sexually violent predator. In People versus Rowland, R-O-W-L-A-N-D, at 207 Pacific 3rd, 890, Colorado Supreme Court, 2009. That statute requires the court to use the results of the SVP risk assessment to make findings whether the offender is an SVP. When we go to the actual scoring document, Your Honor, my position is that if the court is going to deviate from this scoring, you can't, or you will have the inability to rescore it in any way that will come to a conclusion of SVP. The PSI writers acknowledged, strike that, Your Honor. Your Honor, in the People's Memorandum, arguing that you should find SVP, they cite People versus Allen, found at 307 Pacific 3rd, 1102, Colorado Supreme Court, 2013, and suggest that the court there, in Allen, upheld a trial court's SVP finding despite a lack of recommendation based on the screening instrument, which is what it sounds like you are attempting to do. But it doesn't just allow for a very subjective knee-jerk reaction by the court, making a subjective determination. In People versus Allen, it requires, after considering that statute, we hold, and I'm quoting, that the trial court makes the ultimate SVP designation, but should give substantial deference to the screening instrument. A trial court that deviates from the results of the screening instrument must make specific findings on the record to demonstrate the necessity of the deviation. It wasn't just a general subjective determination, but in People versus Allen, the trial court rescored. They utilized that screening document to rescore not to make a general determination that this case is bad enough for an SVP finding. Your Honor, if the court were to rescore and go through the risk determinations, which are in Part 3 of the SVP scoring instrument, that is on page 6 of 7 of the scoring document, it finds that with a score of 8 or higher, that is one of the requirements to a finding of SVP. Austin scored a 2, and he only scored a 2 because the age of the offender at the time of the index offense scored 2 if the offender was 25 or under. Had he been an age of majority, an adult, it would have only been a 1. He is far from the required 8 points. Your Honor, with regard to the sexually violent predator and such scoring, my argument is based on Austin's rights under 18.3.414.5, due process under the 14th Amendment to the United States Constitution, and Article 2, Section 25 of the Colorado Constitution. That is my argument, Your Honor, with regard to SVP determination and my objection to anything deviating from the scoring instrument. That's part of the PSI.
Thank you. And I'll make some findings. Is there anything further that you want to present? Kind of in the nature of that.
I have something further, Your Honor. Your Honor, I want to be clear, just in case I've forgotten, that with regard to my memorandum of law, my argument that anything above a lifetime sentence with the possibility of parole after 40 years, that argument is based on Austin's due process rights, his right to counsel, equal protection, cruel and unusual punishment, compulsory process, and right to appeal under the 1st, 4th, 6th, 8th, 9th, 10th, and 14th Amendments to the United States Constitution, and Article 2, Sections 3, 6, 7, 10, 11, 16, 18, 20, 23, 25, and 28 under the Colorado Constitution. Your Honor, Austin, and I would posit that his family as well, are incredibly sorry for the loss that the community, and particularly the Ridgway family, has experienced. With that said, Your Honor, and I said at the beginning this morning, you are my audience, and so I say this because I think you may understand, perhaps not the public listening in, that it has been an honor to represent someone who is considered probably one of the least of the brethren. Someone who most people in this courtroom may come to a quick decision that there is no redeemable value left in this young man, in this person, this child who committed who pled guilty to a heinous act. Your Honor, the District Attorney's Office, their deputies, and defense counsel have litigated zealously and have engaged in a very zealous manner the adversarial process. In that, the family, both the Ridgway family and the Sigg family, have always been very noble and appropriate to the court and to one another. It has been clear from the beginning of the proceedings that the Sigg family has chosen to wear purple as a sign of recognition of loss. Perhaps defense counsel wears purple on the inside, recognizing that loss as well. The thing about this, Your Honor, is that so much argument to you is an attempt to get you to understand through speculation and jumps in logic, using an adult, fully formed brain, of what happened. Wants to use your ability to reason and use logic and input that onto a child who did a very bad thing. That is not possible. You can try to understand. The defense has submitted mitigation. Mitigation not explaining away, but to the extent we can, using adult brains, understanding what took place. But the case law recently, the recent shift in case law, has recognized a deficit in children psychologically and developmentally. The court may not forget that in imposing its sentence. Your Honor, I humbly suggest that a sign of a great judge is one that recognizes the limits and parameters set by the people through the legislature. There should be a recognition of limitations of a judge's ability to understand the appropriateness of Austin being paroled. What I mean by that is that the court is limited in its ability to determine if Austin will be appropriate for parole when he is nearly 60 years old. The court would be presumptuous and speculative to assume at this early age, because of an act by a child, that that child would never be appropriate for parole. Your Honor, I submit that you cannot surely know if he, Austin, will be inappropriate for parole, and the court should recognize the separation of powers, which I've alluded to earlier in my argument. People versus Oglethorpe at 87 Pacific 3rd, 129, Colorado Court of Appeals, 2003, in dealing with an indeterminate sentence, stated this: the separation of powers doctrine prohibits the exercise by one branch of government of the powers that the Constitution vests in another branch of government. With respect to sentencing, the General Assembly has the inherent power to prescribe punishment for crimes and to limit the court's sentencing authority. The imposition of a sentence is a judicial function. Once a sentence is imposed, the executive branch is responsible for carrying out the court's mandate. The decision to grant parole to an inmate incarcerated for an indeterminate sentence is vested within the sound discretion of the state parole board. If you impose any sentence beyond lifetime with the possibility of parole after 40 calendar years, Your Honor, you are overreaching. You are going beyond the power that you have as a judge and are crossing over into the powers of the executive branch and the parole board. Your Honor, in paraphrasing Miller versus Alabama, there is great difficulty in distinguishing within a child whether the rare juvenile offender's crime reflects irreparable corruption or the child's offense reflects unfortunate yet transient immaturity. Your Honor, you are sentencing a child today. Life with the possibility of parole in 40 years is the only legal and appropriate sentence.
Sigg, this is your last chance to allocate. I'm not saying you need to, but I want to make sure you understand you have an opportunity, if you have the right to speak to me before sentencing. Do you understand that?
Yes, Your Honor.
Okay. Mr. Doran, I don't need any response other than if you want to respond to the sexually violent predator argument that was made. I'm not requiring it, but
We submitted factual findings which are supported by the record, Your Honor. Thank you.
thank you. Thank you. Give me a moment. I'm going to first address, this is a little bit out of order, I'm going to first address Mr. Lohr's concerns that I am limited and should be limited in my sentencing decision in this case. Given the facts and the aggravation in this case that's been presented to me, and I have had a chance to, not chance, I've been required to review matters that were submitted under Sigg in camera that were not published and probably should not be published as to evidence in this case that would have been presented to a jury and would have been required to be presented to a jury if this case had gone to trial. Here I want to stop and thank Mr. Sigg for his pleas of guilty to all the outstanding charges. By doing that, sir, we relieve the 16 people sworn to try this case, court staff and the public, of reliving over the next 2 weeks the facts of this case and the experiences that Jessica went through on the day of her death. So I want to thank you for not having us go through that. However, given the facts of this case that I'm aware of and what's been acknowledged and admitted to, this case cries out for my sentence. I'm limited. I understand that I'm prohibited by statute from imposing what would be the most appropriate sentence in this case. If I had the discretion, I would not hesitate to impose a life without parole sentence. But I can't do that. I don't believe, though, that by imposing additional conditions that would violate the Eighth Amendment. My understanding of the law is, and it was based previously, that the Supreme Court, I'm not talking about the Colorado Supreme Court, the United States Supreme Court, has acknowledged that there are some cases where the facts and circumstances might be such that a juvenile, someone under the age of 18, could be sentenced to life in prison without parole. If that would be permissible under the Eighth Amendment, I don't see where this court, in imposing consecutive sentences that would expand, that might modify the 40-year parole, would be a violation of the Eighth Amendment. Those are my findings. Let me go now to the sexually violent predator issue. I'll note that under the instrument, that I've looked at the instrument, that one of the issues was that Mr. Sigg elected not to participate in the assessment. That's C, paragraph 3C, mental abnormality. And there are various criteria that they go through for that, for both the first part and the second part of that. Given the evidence that was presented, and given what I've seen in the evidence in this case, if that had been presented to the screener while this instrument was being used, as testified to by the doctor, I think that that would have been an aggravating factor for the scorer to go through this if they had that information and had the ability to have that information. There's some other matters here. They have one matter as to be specific. Age of the offender is stored at 2. The offender was known to the victim. No matter what he said, there was some evidence of the photograph and the way that he had the child dress to mimic her cheerleader's outfit, etc. The offender has not graduated from high school. They give him a 0 on that. At the time of the arrest, if he did not graduate, score 1. The definition of graduation excludes receipt of a GED unless the offender also attended any post-secondary education program, college, grade school, community college. Given this factor, as to the attending and the circumstance in this case, I question whether or not that should have been scored the way it was. 5, the offender has 1 or more adult convictions. Obviously, he does not. By his admission in this case, he offended and committed an attempted kidnapping for the purpose of sexual assault and murder about 4 or 5 months prior to this. That is not a prior conviction, but by his admission, it was a prior violation of a very, very serious conduct. I don't know what the Court of Appeals would do, or someone else would do, if they're reviewing this instrument. If this instrument, given these facts, does not assess someone as a sexually violent predator, the instrument needs to be changed. It's inappropriate. As to the sentence, I'm going to go through numerous counts. Many of these counts are enhancers, crimes of violence, etc., that enhance the potential penalty. As to count 1, it's murder. To that count, I'm sentencing Mr. Sigg to life imprisonment. Under the current limitations I have by the legislature, he is by statute eligible for consideration for parole after 40 years. Pleadings counts 3, 4, and 5 are also the murder counts. They merge into that count. Count 5, second-degree kidnapping. Mr. Sigg is sentenced to 48 years in the Department of Corrections. That's specifically consecutive to the sentence I announced for count 1. In count 6 is a crime of violence. He's admitted those. As to count 7, that second-degree kidnapping. Let me go to my notes on that. As I said, count 7, that's second-degree kidnapping. That's a class 2 felony. That carries 16 to 48 years is what I was looking at. Mr. Sigg is sentenced to Department of Corrections for 48 years on count 7. That's specifically consecutive to and not concurrent with the sentence I announced at count 1 and the sentence I announced at count 5. On count 9, that sexual assault of a child. On count 9, that's a class 3 felony. Mr. Sigg is sentenced to 24 years to life. It's an indeterminate sentence. Minimum of 24 years, maximum is natural life. That's also consecutive to the sentence I just announced as to count 1 and count 5. Count 10 is a crime of violence, count 11 is a robbery. That's, he's sentenced to 5 years on robbery. That's specifically concurrent. That is not consecutive with the other counts I just announced. Count 16 has to do with the Pepper Lake jogger. On that, he acknowledged the penalty was up to 8 years and not 6 years when we started the sentencing hearing. He is sentenced to 8 years in Department of Corrections. That specifically consecutive counts 1, 5, 9, and all other counts that he is sentenced on in this case. 17 is a crime of violence. 18 is sexual assault. I believe that is merged, and I find that merges with count 9. That sexual assault count merges with count 9. Count 19 is a crime of violence. Count 20 is sexual exploitation. I believe that's count 20. That's count 20 is sexual exploitation. Count 21 is sexual exploitation of a child. And count 22 is sexual exploitation of a child. I find that on count 20, he's sentenced to 6 years in Department of Corrections. That's specifically consecutive to the sentence I announced on count 1, count 5, count 7, and all of the counts. Count 21 is sexual exploitation of a child. That carries 6 years. Count 22 is also sexual exploitation of a child, and that carries, I think, 4 years, 2 to 4 years. Those are both specifically concurrent with count 20 that I just announced. So all of those sexual exploitation charges will be concurrent with the 6 years I announced on count 20. Those are my sentencings as to those counts. Finally, I cannot emphasize as much as how this crime has affected the courts, how it's affected the communities, and sure as how it affected both the families. On October 5, 2012, Jessica Ridgway left school at Witt Elementary at age 25. She never arrived. The search for Jessica was the most massive in the history of Wheat Ridge and Jefferson County. Hundreds of volunteers, in addition to police, fire, federal law enforcement agencies, and children, joined in the search for Jessica. And that occurred day and night, went on for day and night. On October 10, 2012, the dismembered body of Jessica was found in an open space area west at the intersection of West 82nd and Quaker Street. On October 19, 2012, as a result of a tip, agents went to the Sigg home and took a DNA sample from Austin Sigg. On October 23, 2012, Mindy Sigg called the Westminster Police Department and reported that her son, Austin Sigg, had confessed to her he had kidnapped and killed Jessica. That same day, Mr. Sigg was interviewed by Detectives Lynch and Boatwright. Austin Sigg acknowledged that he was responsible for the kidnapping and death of Jessica and the kidnapping of a jogger at Pintner Reservoir on May 28, 2012. A jury of 16 was selected to try this case. They were sworn to involve the kidnapping and murder of Jessica. That was to start on October 3, 2013. The Pintner Lake counts were severed. Mr. Sigg entered pleas to all charges on October 1st, 2013. By his plea, he acknowledged his guilt and therefore spared the jury, families, and so forth of having to live through the last day of their life, of her life. Based on the work of the law enforcement personnel, investigators, and the statements of Mr. Sigg, we know what happened. What still is a mystery and may never be understood is why an intelligent young man from a good home, good family, advantages, financial security, and love of his family, and good thoughts of his teachers, parents, and associates, decided to kidnap, terrorize, and brutally murder a 10-year-old girl. I've heard that from everyone. Why did this happen? We know this, we know that, but why did this happen? The only answer I can come close to in finding was stated by Chief Burke in his statement, and also referred to by Mr. Sargent in his statements. That was given to Detective Lynch and Detective Burke on October 21st, 2012. As I noted, the exact quote is as follows. I don't know about society because I've never really been that great with it, but I know that personally I am a monster for what I've done. I couldn't find a better word to describe evil than exactly what I've done. Evil is apparently real. It was present in our community on Friday, October 5, 2012. On that day, his name was Austin Sigg. It's my order that Mr. Sigg be taken by the Sheriff of Jefferson County by him transported to the Director of the Department of Institutions, there to be confined for what I anticipate will be the rest of his natural life in light of these sentences. You'll take the prisoner next.
Senator, we do have some housekeeping matters to address with you.
Before we, all right, your name, you may be seated. What are the housekeeping matters?
Your Honor, I understand from your ruling that you have overruled my argument of law about the imposition of sentence going beyond lifetime with the ability to parole after 40 calendar years.
By making some of these sentences consecutive as opposed to concurrent?
Yes, Your Honor.
That's what I've done. I've made them consecutive.
Understand. Your Honor, and also with regard to the sexually violent predator finding that you have made, I was objecting in anticipation. I do now formally object and incorporate my argument and law into that objection.
Your objection is noted.
Your Honor, we also have housekeeping matters with regard to motions filed by the prosecution with regard to restitution, cost of prosecution. And
you object?
Your Honor, we do object to the cost of prosecution.
File a written objection, please, and I'll pick those up.
We do. Your Honor, then we have a matter of the district attorney's presentation in form of video that was presented yesterday to the court. We would like that made part of the record and submitted to the court.
I'll order that part of the record as for your video if you need for sentencing, or as for your PowerPoint if you need for sentencing. For the appeal.
To clarify, Your Honor, we do not object to the restitution requested by the prosecution to date. If there is more requested, we reserve right to object.
The restitution request as proposed is ordered. Anything further? Housekeeping.
We assume the court is going to find the pre-sentence confinement as indicated in the pre-sentence investigation report.
It is what it is, correct.
And
I believe that I just pushed that away. I show pre-sentence confinement as of November 18th, 391 days.
That's acceptable to the defendant.
We have a few more days. That was as of Monday, November 18th.
392.
Today, 392.
Yes.
Just to clarify counts 5 and 7, Your Honor, those are the two different kidnapping counts. Did the court say they were, because there's really one kidnapping, the court said they were concurrent with one another?
They're both alleged kidnapping of Jessica, correct?
Correct. There are two different theories upon which the enhancement, but they're one kidnapping.
They murdered Stan.
Thank you. So they're consecutive to everything else but concurrent to one another.
Absolutely, that's what I thought it said.
Thank you very much, Your Honor.
Anything further, Mr. Lowe?
Nothing else, Your Honor.
You may take me next. You may announce your recess.
All rise. The court is now in recess.